Good morning, everyone. My name is Judy Blake, and I am the Leadership and Advocacy Coordinator for Family to Family Network. I am so thrilled to be collaborating with an amazing Lone Star Len trainee, Hazel Go, who reached out to me, wanted to do more to impact her community and to have training sessions to educate and empower the Asian American community. We're very, very happy to have our last session, and thank you so much for joining us. Hazel, it's all up to you.
Thank you. Yeah, thank you everyone for participating. I know there's been some repeat. People have been coming.
Hazel,
really,
we can't
thank
hear
you so
you
much
that
for
well.
supporting these 5 sessions that we had. Can you
You're
hear me
breaking up.
better now? Sorry.
That's okay. Yeah, I think that's better.
My Wi-Fi is a bit spotty.
Okay. Yeah, no worries.
Okay, sorry, my Wi-Fi is a bit spotty. Yeah, so thank you everyone for coming. It's been 5 sessions that we had. This is the last one. I really appreciate everyone who's been coming to join us. We have been sending out summary notes, though they've been coming a little later than we wanted them to. And these summary notes come with Mandarin and Vietnamese translations. So if there's anyone in your community that you feel would really benefit from this information, feel free to send the translation or like the summary notes to them. And this will also help you to recap if anything. Our lovely speaker here today, we have Jennifer. She is an attorney, and she has been engaging in legal practice that includes commercial litigation, business formation, real estate transactions, estate planning, and probate since 2009. In 2014, she founded the Chiang Law Firm, and today it's a fast-growing full-service civil law firm serving clients in the greater Houston area and abroad. In 2015, the Sugar Land City Council appointed her as the Associate Municipal Judge for the City of Sugar Land. She's also a member of the Real Estate, Probate and Trust Section, Family Law Section, and Asian Pacific Islander Interest Section for the State Bar of Texas. She's also a board member and a fellow of the Texas Bar Foundation and a member of the College of the State Bar of Texas. So a whole lot of things. She is also a board member of the Portland Young Lawyers Association. She is also a member of the Chinese Baptist Church. And we are really grateful for her today to share more about estate planning. So let me just pass over the time to Jennifer. She will take questions whenever, so feel free to type them in the chat. If you want to remain anonymous, you can send the questions to either Judy or I anonymously, and we can bring it up to Jennifer as you need to. All right, Jennifer, take it away.
Thank you, Hazel. I'm going to share my screen with my presentation.
I just wanted to say too that don't slides along with the summary notes later on.
So thank you so much for everybody for coming today. As Hazel said, my name is Jennifer Chiang. I am the owner of Chiang Law Firm, and I am passionate about serving the Asian American community. My family has been in the United States for over 100 years on my mother's side, but my father is actually a recent immigrant, recent as in, you know, he came in the 70s from Taiwan. And so I've seen the Asian experience, I feel, from both sides, from the side of someone whose family's been here for a while and has been pretty established, but also the side from someone whose family came over relatively recently. And I know that in my personal history, if you attended any of the other previous presentations, you know, I see what it's like where a lot of times Asians they don't like talking about personal struggles. They don't like talking about you know, the like mental health issues or illnesses that you can't really see with strangers. And also another thing is that they don't like talking about death in the Asian community, or at least in the Chinese community that I grew up in. And a lot of people with disabilities were basically hidden away. We don't institutionalize people anymore, but if they, you basically saw people completely recede from society. And my goal is to give you and your loved ones the tools that you need to empower yourself so that you don't have to recede from society, that you and your loved one with a disability, or not even a disability, but just different abilities, can fully participate in society as much as you want to, but with the love and support and help that they need so that they can participate fully in society. So the first thing I'm going to talk about is a guardianship. What is a guardianship? A lot of you may have heard of guardianships, but not quite know what they are. Guardianships are when someone is unable to make their own financial decisions, healthcare decisions, or housing decisions, and therefore need someone to make those decisions for them. That's the most simple version of a guardianship. And a legal guardianship is a court-mandated relationship where the court says, I'm going to appoint someone to be the guardian, and the ward is going to be the subject of the guardianship. So the ward is the incapacitated person. And an incapacitated person can be a minor. It can be an adult individual who's unable to provide for themselves physically and or financially. And in addition, a person must have a guardian. Well, actually, that's not necessarily true. Sometimes you can have a designated person to receive the funds from a governmental source, and that's actually the representative payee person, but it definitely helps to have a guardianship. So one of the things that I want to share with you is that we can actually use guardianships for a lot of different situations. We can use guardianships for children. Say if two parents have both passed away, we can actually appoint a guardianship for a minor child so that somebody can take care of them and somebody can manage their finances. But for our situation here, we're probably talking about a person with a developmental disability, maybe 18, 19, 20, or even 40, 50 years old, who needs someone to make medical decisions, to make housing decisions, to make financial decisions, because they simply can't care for themselves. Now, one of the questions I frequently get asked in my presentations is, when should I start thinking about getting a guardianship? If you are the parent or caregiver to a disabled adult. And to be perfectly honest, the answer is as soon as possible. Maybe not in the 2, 4, 5-year-old range, but really when your child turns about 16 or 17 years old, that's when you really need to take a hard look at their abilities and what their future is going to look like after they turn 18, because the age of 18 is basically the line of when someone in Texas is considered an adult for financial purposes. And so if a guardian isn't appointed, then you won't be able to care for your child's finances. For Medicaid reasons, they say that 18 is a cutoff date for a lot of things. And so you really need to look at doing this process right around somebody's 18th birthday. And the process to get a guardianship is first, with talking to your healthcare team, your therapists, your teachers, everybody, assessing this person's needs and abilities. And if it's just clear that there's, no way that this person can be expected to manage their own finances or make medical decisions for themselves or make housing decisions for themselves, then you will go to a doctor, get a doctor's letter, and then file an application to get that guardianship. You'll notice all the interested parties. The court is going to appoint a third-party attorney to investigate the guardianship. They will come and they will talk to your loved one and see for themselves what are their needs, what are their abilities. In the past, I've acted as that ad litem before in a number of different cases. I will physically meet the proposed ward when I can, and I'll try to talk to them. If they were recently in school and have a special or in special education plan or an IEP, I will look at that. I will look at their medical records, and I will talk with the family and the proposed guardian to see, to really get a good idea and assess where is that person's ability levels. Is it in their interest? Do they want this guardianship? Do they want this person to serve as guardian? And the clerk will also have to issue a citation, and we will have to personally serve the ward, which can't be done by mail. A police officer actually has to physically go and bring the citation to that person. And it can be a little bit scary if they don't understand what's going on. As the proposed guardian, you'll have to go through a process of going through a background check and taking a guardianship course that's mandated by the court. We will have a hearing in front of the judge. And then if the judge agrees that a guardianship is necessary, the court will appoint a guardian. He or she, the judge, will require the guardian to sign an oath saying that they're going to do everything that they're supposed to do as guardian. And they will actually make the guardian put up a bond. Now, for many of you who had minor children who are disabled, they might not have much of an estate, and the judge won't make you put up a very large bond, maybe $100. But if the child inherits something, or if you're getting a guardianship over a disabled older person, say, grandma and grandpa who's 80, 90 years old, and they're starting to lose it a little bit, and maybe they need somebody to help them manage their finances or dictate their living because they had a stroke or whatnot, and you need a guardianship for whatever reason, then grandma and grandpa might have a sizable estate of millions of dollars potentially, and you would have to to be a guardian of that person, you would have to get a bond for that amount of money, which is a big concern, especially if someone doesn't have very good credit. Someone is, not working at a very good job. Bonds can be pretty expensive sometimes. So that's another thing to consider about the appropriateness of who can be a guardian. And I wanted to actually briefly talk about who can serve as guardian. One of the important things about who can serve as guardian is obviously the parents who are interested people in being a guardian, as well as brothers and sisters and siblings. Typically, the court really likes to see family to serve as guardians because, it's one of the things I love about Asian families is that Asian families are very tightly knit, and they really do take care of one another, and you really feel a strong duty to take care of your your parents, or you take care of your siblings, or to honor your parents' wishes if they wanted to, you to take care of your siblings. And however, some people simply just are not allowed to be guardians. One of the people who cannot serve as guardians is anybody who has committed a felony. You are automatically disqualified from serving as guardians. Also, people who have done things that are notoriously bad conduct. So maybe you haven't committed a felony, but you have a brother who could be serving as a guardian who has spent, has been in and out of jail for the past 7 years for minor misdemeanor things. That person, probably not the person you want to serve as a guardian. Another person you don't want to serve as a guardian is someone who owes money to the proposed ward, because that person's going to take over their finances. And, those are really the big 3 reasons why you could be disqualified for serving as a guardian. Oh, another thing as well, somebody who's under the age of 18 cannot serve as a guardian. And so, and I'll toss this in as well, because we're talking to an Asian American group. I have a lot of my clients who propose to me, hey, if something were to happen to me, could my sister that lives out of state serve as my guard? She lives in California, she lives in New York, or can my sister who lives in Canada or Hong Kong or China or Taiwan serve as a guardian? And my answer to that would be maybe. Are they willing to move to Texas? Which is a really long, complicated way. To shorten up the answer is my guardianship elections, which we'll get to. If you want that person to serve as a guardian and to have a guardianship in Texas, there is a process where you can transfer guardianships to other states in the United States, because we have the Constitution, the full faith and credit clause to do that. You can transfer a guardian to a different state. However, transferring a guardianship from, say, Texas to Canada is a little bit tricky. Texas to Taiwan, et cetera. Again, a little tricky. We would actually have to go through a process of getting your sibling appointed first here in Texas, which is possible, but again, a little bit tricky. And then they would have to ask the court to move the ward. And you can see in situations where, say, for example, I know in Taiwan, they actually have a pretty robust healthcare system there. Why, and it might make sense to move a ward over to Taiwan, but you do have to go through the process, apply here, and ask the court for permission to do the transfer. And so pros and cons of guardianship is, number one, as I said, it's the court supervision. Guardianships are set up to protect some of the most vulnerable people in our society: disabled people, handicapped people, elderly people, minors. And we want to make sure that they are taken care of. So the court is there to make sure that, you file a report every year to tell the court how's the ward doing. Is the ward being educated? Is the ward receiving medical care? Is the ward going to move to a different place, even from facility to facility in the state of Texas, or even in the county? And another benefit is that once you've turned 18, or once the ward has turned 18, it's where that person, otherwise in the eyes of Texas, would be allowed to go out, get a driver's license, go and vote, and buy guns, or just live their life as an independent adult. When it's someone who just can't do that, you can have somebody do that for the ward. The guardian establishes the residence of the ward. The guardian consents who can see the ward, consents to medical treatment, and can manage the estate of the ward. And these are all, things that, if for some people are absolutely necessary. Now the cons. The cons are that guardianships can be pretty expensive. I know that when I do guardianships, I tell my clients that they should budget at least $3,000 to $5,000 to get a guardianship. And I tell them that, you know, the reason why it's so expensive is that there's my fees in the guardianship, but remember that attorney that I told you about, the other attorney also is owed a fee as well. Now, depending on your ability to pay, the counties do allow for indigency affidavits, so you won't have to pay for the guardian ad litem, the other attorney, but you still have to consider the hiring the private attorney cost. And there are some programs out there. I know some legal aid programs are out there for people who simply cannot afford an attorney. However, you have to meet certain poverty guideline requirements if you cannot afford an attorney. It's also a lengthy process. I tell my clients that on our best day, we can get a guardianship done in maybe 6 months. Faster in Harris County than in Fort Bend County, where I primarily practice, but in Fort Bend County, it usually takes maybe 6 months to 9 months, is probably more common. And some people say, oh, well, I didn't know that it would take this long. And I was like, well, that's one of the reasons why I said you should probably start before your child turns 17, so we can get everything in place so that we can file in a timely manner, so that there will be as little disruption in this person's life as possible. Again, a con is the court supervision. You will have to do that annual report. And if you don't do an annual report, you could be in contempt of court, which is a fancy way of saying you could be in trouble with the judge. They might call you in to do a hearing in front of them so that you can personally explain to the judge why you did not do your annual report. And also, there are limitations to guardianships. Guardianships don't solve every single problem that's out there. Guardianships don't solve, your ward from making bad choices or doing bad things in life. It just helps you mitigate how many bad choices or doing bad things that the ward can do by putting them in a better and more supportive environment. Also, and this is one of the things that in recent years, Texas has tried to limit. If you think about it, if you have a guardianship appointed, you basically lose very important rights that we think people should have to participate in society. The ward will lose the right to vote. The ward will lose the right to get married. The ward will lose the right to have a driver's license, unless these rights are specifically carved out in orders. And another thing that is a limitation or a con is that certain family members can lose access to the ward when somebody is appointed as guardian. So unless the guardian makes a very concentrated effort to include all the people in the ward's life who are supportive and the ward wants to be involved in their life, those people can lose rights. I've seen this become a problem more in the context of when older people have guardianships appointed over them, where maybe they wanted to have all their children around, but due to the efforts of one child trying to control the ward's assets and the ward, that person may have cut out the other siblings just to manipulate the situation, which is very sad. So another thing that we would strongly recommend is to consider alternatives to guardianship. So this is part of your homework if you were going to seek a guardianship. We would go through, if you were to come to my office with a 17-year-old who is on the autism spectrum, I would go down this list of things, and I would talk to you about, and frankly, I would meet with the proposed ward as well as your child, or your person, to say, okay, could we do something that resolves the concerns that you have without actually doing a guardianship? So number one, I would say, does this person have capacity? Do they have, the independent decision-making skills to manage money, or to tell us where they want to live, or to make healthcare decisions, or to let their doctors and nurses say who they want to have, or what treatments that they want to have. For some people, they just don't have the capacity to consent to a medical power of attorney or durable power of attorney. And medical power of attorneys allow the appointees to make medical decisions on a ward's behalf, and a durable power of attorney permits the appointee to make financial decisions on the person's behalf. And if they just don't really have that capacity to do that, then maybe we need to look at something else. Maybe they just need to have some mental health treatment, and then they'll regain capacity. Or maybe they'll just need if you just need someone to manage Social Security money, maybe that we can do an appointment of representative payee to manage public benefits. For the VA system, for veterans, and for the Social Security, they both do representative payee. So one of the things that we can do in guardianships that actually helps the court operate a little bit more efficiently and allows a little bit more freedom for families is that if you wanted to get a guardianship for a child who is receiving SSI benefits, or will be eligible for SSI benefits when they turn their own SSI benefits when they turn 18, you can actually just do a guardianship of the person and not of the estate. And the court will just acknowledge that the money, the representative payee account, will be managed by whoever the representative payee of the ward is. And then that way it kind of cuts down on the financial reporting to the court, because otherwise the court's going to ask you, hey, as part of your annual report, you're going to have to account for every single transaction out of the ward's bank account. Another way of minimizing the need of guardianships is to establish joint bank accounts. Again, this is especially effective for older adults. Creation of management trusts or special needs trust. We'll talk a little bit more about special needs trust later on in the presentation. Designation of guardian before need, so that in the event that a guardian was needed, then that person will be able to take their designation to the court and show the court that this person wanted me to serve as guardian. Again, that's something that I usually deal with in my guardianships with older adults. And just doing more person-centered planning and supported decision-making agreements. Supported decision-making agreements are something that's very interesting that has come to play in the past couple of years, where a disabled person can actually name a supportive person, a person who's responsible for helping them seek medical treatment, understand their options, and to communicate their desires to their doctors and nurses. And it's kind of like they're not supposed to put their decisions in instead of the ward. They're supposed to help communicate what the ward wants. And this has been a pretty effective tool in a lot of different situations where you don't want somebody where your potential ward actually has a lot of different abilities, actually has the ability to understand their healthcare needs and their healthcare wishes, but has trouble maybe communicating, maybe organizing, maybe really effectively obtaining their healthcare for one way or another. And this does allow someone to help organize, communicate, and help express the wishes of the potential ward, and might not eliminate the need for a guardianship, because again, courts really don't like guardianships when they're courts really don't like guardianships. Part of the reason why is because they're, like I said, they're lengthy. Once you have a guardianship, it's permanent. And so if you could imagine, the court is responsible for these reports and for monitoring their ward from the time they turn 18, if you have someone who is disabled at a pretty young age, to all the way until the end of that person's natural life, and 60 years old even. So that's over 40 years that the court's going to have to manage this person. And what you really have seen the courts do to eliminate the need of guardianships is to very much encourage the alternatives that I showed in the previous slide, to encourage the use of durable power of attorneys, medical power of attorney, supportive decision-making agreements, representative payee accounts. I see in the courts that I've been in, a lot of times they really want, the only kinds of guardianships that they really want to see are the ones where you have a young person who's disabled at a pretty young age who does need a guardianship. They really, for a permanent issue, they really don't like seeing guardianships for older adults who, like I said in my previous example, mom had a stroke at 70 or 80 years old, and but she has a durable power of attorney and a medical power of attorney that she did while she was healthy. The court generally disfavors those kinds of guardianships just for the sake of getting a guardianship, because they feel like with a medical power of attorney and a durable power of attorney, you can basically do everything that you or 90% of what you need. It's usually not everything. So naming a successor guardian, I kind of previewed this a little bit, because ultimately, especially if you are a parent caregiver, there is a strong likelihood that you might pass before your adult the adult disabled child. And so somebody else will need to be appointed as a caregiver. When you're thinking about naming a successor guardian, and that will typically be done in estate planning documents, that I always ask my clients if they are the guardian of a disabled person, that you should be thinking about it basically from the day or when you're getting appointed as the guardian. You should decide, and you should of course think about who should do this. If you have a spouse, maybe it's that spouse. If it's an adult child, maybe it's that adult child or sibling. If it's another relative, maybe it's that person. But again, you have to go through the whole decision-making process of, if I'm the guardian of the person, who do I want to make the medical housing decisions for my child? If my child needs financial help, sometimes the person who you want to take care of your child on a regular basis is not necessarily the same person you would want to have manage that child's money. It could be the same person. A lot of times, it's not necessarily the same person. So you might actually get two people involved. Of course, the people who are appointed must qualify to serve as guardian. So again, no notoriously bad conduct, no felonies, no one who owes money to you or your child. And, it would also be fantastic if you thought about someone who really would treat the child as putting their child's interests above their own. You want someone who, and that's essentially the fiduciary standard, which is the standard that durable powers of attorney, and guardians are held to. The person who is a guardian is essentially a selfless person because they put somebody else's interests above their own. And that's the person who you want to pick as your guardian. Now, you might have geographic concerns as well. Obviously, if the person was living in Texas, it's easier because we have between counties, it's an easier process than trying to transfer a guardian across state lines. But again, you want that selfless person who wants to put their interests, the interests of the ward above their own. So I previewed that we were going to talk a little bit about estate planning, and estate planning is a really important component of special needs planning because ultimately, especially if you are caring for an adult guardian, and even if it's not your child, if you are a relative of someone who has special needs, having a good estate plan in place for yourself and certain trusts in place for that person with special needs as a part of your estate plan, especially if you're planning on leaving money to that person, is critically important. For all of my clients, regardless of how many children you have, what their abilities are, or whatever their station in life, I still recommend you will need a will. You will need a durable power of attorney. You will need a medical power of attorney. You will need guardianship elections, healthcare directives, and HIPAAs. So what is a will? A will passes property from one person to another upon the testator's death, the person who wrote the will's death. Now, your will can do a number of things. They can include trusts that have special needs components in them, and we'll talk a little bit about special needs trusts after that. But your will is the cornerstone. If you die without a will, it makes things very, very hard. I'm not going to get into that, but I'm currently working on an estate that has taken almost a year to wrap up, and we're not quite done yet. But it was because somebody passed away without a will. And the problem is if you die without a will, there's a way that property is inherited here in the state of Texas, and it doesn't always make sense to people, and it's not always who you think. So it is usually better to pass away with a will if you are able to have a will. Again, the durable power of attorney and the medical power of attorney designate who you want to make durable power of attorney financial decisions in the event of your own incapacity or inability, and the medical power of attorney is a person who makes medical decisions in the event of your own incapacity or inability. And those are critically important because I always tell my clients that, while we think that, whenever we maybe contemplate about our own deaths, you think maybe it'll be coronavirus, or maybe it'll be a bus or a car accident, but we don't think about the fact that, well, maybe if I was in a car accident, but it doesn't kill me, and what if I'm just disabled? Because that does happen. And if I had a medical power of attorney and a durable power of attorney in place, then whoever I designate, maybe my husband, maybe my sister, maybe at that time my son might be an adult and will be able to help me make medical decisions and help me make financial decisions and care for me. And it just makes it a lot easier for people. So if you're an adult, you should have a medical power of attorney and a durable power of attorney just in case of emergencies. Guardianship elections. Guardianship elections are critically important for yourself, and especially if you are the caretaker of a disabled person, because they tell the court who you would like to have serve as the guardian in the event of your incapacity or your inability to serve as guardian of your special needs adult. And another feature of guardianship elections is not only can you tell the court who you want to serve, you can also tell the court who you do not want to serve as your guardian. So I always joked that, you know, everybody's family is a little bit different, but sometimes you have that, you know, that brother who's been to jail 7 times, or you have that person who just likes to stir up drama in the family that you don't really want to have. You know that they're the person who just you do not want to have managing your property, managing your disabled ward's property, caring for them and designating where to live. And so those are the people who you want to put down, who you do not want to have serve as your guardian, or who you do not want to have serve as the guardian. And the court will abide by your wishes. Now, HIPAAs, I think, and healthcare directives, I think most people understand what those are. Your healthcare directive is your living will. They tell your healthcare practitioners who you want and your medical power of attorney what you want to have done in the event a life-ending decision needs to be made. Your HIPAA is the healthcare privacy laws released so that someone can receive medical information on your behalf. And trust and special needs trusts are not always for everybody, and special needs trusts are not always for everybody, but I find myself increasingly recommending trusts, especially for people who want to avoid probate and who want to add more structure in how their gifts are given to their loved ones, who, especially if you have concerns about creditor protection, protecting your children from divorce, protecting that property, but also protecting minors from owning property, because minors can't own property. And having a trust in place will allow you to pass the money and other property to minors without them actually owning it per se, and setting up a structure for them to receive that money. In the same way, a special needs trust is very important as well. And special needs trusts, I believe it's going to be on the next slide. Yes. Special needs trusts are trusts that are set up for the benefit of a disabled child or disabled adult without affecting their eligibility for public benefits. They are critically important for disabled adults who are going to own property. I work with families a lot, and what I tell them is that, especially if you think that your children will inherit something from, say, a relative, you know, or their grandparents or anything like that, you really need to set up a special needs trust, and you need to emphasize to that relative that all gifts to that child needs to be paid to the special needs trust, or else it would jeopardize that child's ability to get public benefits. One of the issues with Social Security is that, you know, the SSI levels say that you could really only have $2,000 in countable assets in any eligibility month, which means that if your child were to inherit even, you know, $10,000 from their grandma or their uncle, and the uncle thought, oh, it would be so nice for them to have this money. That would actually be a disaster because it would kick the kid off of Social Security and Medicaid. And so since it would kick them off, then the child would have to basically spend that $10,000, and it would basically be gone in a month or two because again, if that person because it's just incredibly expensive. And so you would have to spend all that money down on a Medicaid qualified expenditure. And there's a whole area of law that's actually dedicated towards preserving benefits and eligibility, which I'm not really going to get into, but it's very stressful for families. And so one of the ways to prevent having to go down that, well, what can we spend this money on? Why don't we just set up special needs trusts? And there's two different kinds of special needs trusts. There's a first party special needs trust and a third party special needs trust. So first party special needs trust can be established by parents, grandparents, legal guardians for the benefit of a disabled individual under the age of 65 with assets belonging to the disabled individual so they can qualify or retain public benefits. So for example, if your child were to inherit a large amount of money, like say $100,000 from their grandparents, you can actually set up a first party special needs trust for that child, and they could still after time qualify for SSI and Medicaid. But the government would be entitled to reimbursement from that money. Another use of first party special needs trust is if you are a working adult who actually owns property and will eventually need to qualify for Medicaid. You can use first party special needs trust after a while to qualify for Medicaid. A third party special needs trust, which is in my mind the more preferable way to put money in, but the money has to be structured and the gifts have to be structured in the proper way, is a trust established by a parent, grandparent, legal guardian that is funded with assets that never belong to the disabled individual, so they can qualify and retain public benefits. So that hypothetical $100,000 that was supposed to be spent on, or that was the ward was supposed to inherit, that $100,000 can actually go into a third party special needs trust. It can be used for the ward's needs, and the government is not entitled to be reimbursed from that trust, which is why the third party special needs trust is more preferable than a first party special needs trust. And there are other resources like Able Accounts, Pool Trust, Texana, Navigate, and other things. I literally just noticed that I have 5 minutes. And Judy, were you about to jump in? Or
no, I wasn't.
Hazel?
Would you have a lot more slides?
I have one more slide.
No, you're
Actually,
fine.
yeah, that's it.
No, this goes until 11:30.
Great. Oh, it goes to 11:30?
Yeah.
Oh, hot dog.
Yeah, hot dog.
I felt like I was talking for a lot, but honestly, it's about an hour-long presentation. But I really just wanted to mention that there are other resources instead of setting up third-party special needs trusts. Able accounts are federal accounts that you can make $15,000 a year in tax-free gifts that don't jeopardize public benefits. I believe it's like abletexas.org. The link is something like that. If you Google it,
Yeah,
it's out there.
TexasAble.
Yeah. And there's also pooled trusts like the ARC that can manage the money for you, because being the trustee of someone's money it can be a lot. It does require management and basically being very on top of things. And if you are a CPA, you are that person who I want to manage my trust. If you are my not to make fun of liberal arts majors, if you are a liberal arts major that teaches interpretive dance, that does not keep track of your receipts, you are not the person who I want to serve as a trustee, and maybe organizing assets into an ABLE account or into pooled trusts like the ARC of Texas might be the better solution than having, even yourself doing the managing the trust. And of course, Texana is a huge resource provider out here in Fort Bend County, as well as Navigate Life Texas, and Texas Health and Human Services is basically the big overarching organization and they have a lot of resources and information as well. And with that, I guess I cut myself short. That is my presentation, and I will accept any questions that you may have.
Yeah, there is a question in the chat. I believe it's in relation to special needs trust from Grace Kong. Can we change the appointed guardian at any time we need to? Let's say the ward sibling now is under 18, so they can't be the appointed guardian now. But later, when the minor sibling becomes an adult, the parents of the ward wants to put the adult sibling as one of the appointed guardians.
That's a great question, and the answer is yes, comma, but the adult child must still qualify. So I want to emphasize that guardianships are a court-ordered relationship. So even though we do these guardianship elections where we want to say, where as a parent, you'll serve as the guardian, but you have two children that are maybe 4 years apart in age, and as both of them become adults, you would designate the other sibling as a guardian. You really have to have a discussion with that adult child. Number one, do you want to do this? Because if they don't want to do it, all they have to do is tell the court, I really just don't want to serve as guardian of my sibling, and the court will not appoint them as guardian. They will not appoint them over the guardian's designated guardian's objections, because obviously the court doesn't want to set up a guardianship for failure, because the court needs the guardian to be active and involved in the ward's life. And so you can put it on your guardian designation. I would like my child to serve, and even if that child wants to serve, if they have a criminal background, or if they have anything else in their background that would limit their ability to serve, the court will actually turn them down as guardian. Oh, if the ward has an estate, a sizable estate, and your child doesn't have very good credit and won't be able to get a bond, because that's basically like applying for a credit card in a lot of ways, where if you can't qualify for credit to get a bond large enough to cover the estate, the judge really won't approve of that guardianship. So in most family situations where those things aren't a concern, absolutely designate your adult child to be a successor guardian, and have, upon your incapacity. And I would suggest strongly that really as soon as you are unable to serve as a guardian, you have that child be appointed as guardian right away. So one of the sad things that I had to do a couple of years ago is appoint a successor guardian for a disabled adult in Fort Bend County. And they did everything right, but because the mother passed away so suddenly, she actually died in a car accident. She wasn't sick for a prolonged period of time. She passed away in a car accident. The successor guardian basically had to wrap up the estate first. By the time she did that, then she said, oh, I actually need to apply to be the guardian of my sister. Well, basically 9 months had already passed by then, and we were starting to basically reach problems in the estate. No one was spending the money that was accruing in her account, and she was about to get kicked off of Medicaid, and it became a absolute emergency to get her appointed. And my encouragement to you is to really have that discussion with who your successor guardian is going to be at the very first inkling that, man, maybe you shouldn't be doing it, once, if you yourself experience illness or life changes where you don't think that you can do it for right now, but you don't know how much longer you can do it. You really need to start planning and preparing for that succession, because even doing a successor guardian appointment is going to take, it can, depending on the court. Out here in Fort Bend County, we work a little bit slower. I tell people, again, 6 months on a really good day. Harris County is a little bit faster. You can probably get it within, 2-3 months for a successor guardian, but really it depends on what kind of county you're in. Any other questions?
And feel free to unmute yourself as well if you want to ask the question early too.
Also, too, for the person who is J. Kim, I'd sent you a private message. I just wasn't sure of the name that you registered with. So if you could private message me back and let me know, that would be great. Thank you.
I think I saw Ben have a question. I saw that they are muted.
Hi, we have a question actually.
Hi, May. Please ask your question.
Jennifer, I do have a guardianship and the will together with other senior lawyer couple years ago, but now things changed. I want to probably will change my will. So are you okay with that?
Like, do I provide that
I
service?
need to redo the special need trust. I do have a special need trust for my child, and I do have a guardianship, which is running very good. But I want to change my will. So will you taking care of this kind of case?
Absolutely, we do these kinds of cases all the time. And if my contact information is on the final slide, and I think Hazel is going to circulate the information as well.
Okay.
So, Robin, I think you had a question too.
And do you want to stop sharing your screen? That way we can kind of see everybody. Thank you so much, Jennifer. Excellent presentation. Robin had asked, we are just wondering if special needs trust has to be set separately from other educational trust.
So it depends on how the trust was set up. I mean, part of the problem is that trusts have so many handy dandy purposes. And I know that in my own practice, I create vastly multifunctional trusts because I do tend to put in special needs languages in there, as well as contingent minor trust in there, as well as creditor protection things in my trust. And so the answer is, I'm not quite sure what your educational trust, like what kind of language is in there. But if your educational trust in there has special needs trust language, then no, probably not, unless you have another purpose for the trust, which is the most lawyer-like answer I could possibly give you.
Which means you need to review it in order to answer.
Right? The answer is yes, maybe.
Okay. Yeah, so we have pretty young children. They are age 6 and 4, and our 6-year-old has special needs, but our 4-year-old is neurotypical. So we are in the process of like setting trust for like both of them. But I just wonder if it has to be like, separate, because I've been hearing a lot about like government issued educational trust, like there's a Texas plan, there's Utah plan, and such. So I just wonder if like we have to do a completely separate research and separate products for our 6-year-old and our 4-year-old. If that makes sense.
No, definitely. So, okay. So, like 529 plans have their own set of rules, and I mean, and this is where things get really, really difficult because I'm assuming is your 6-year-old on the spectrum?
Yes.
So with the 529 plans, you know, you can talk to a financial advisor about them. And one of the great things about them is that if your spectrum daughter can't eventually use it for whatever reason,
Yeah.
like she might decide, I don't want to go to college, I want to go become a bake artisan sourdough bread, which apparently costs like $100 a loaf these days. So that might not be a bad job.
Okay.
But, you know, I mean, there's lots of reasons why people don't go to college. Then you can actually designate the 529 to another child, but it does have to be used for educational expenses. Otherwise, I believe it does get taxed after the fact.
Okay.
So there's that aspect. And that is totally separate from what your estate planning should be for your children. And and that's one of the reasons why I did the whole, ooh, I don't really know what to do for your kids, because truth be told, I know Hazel and Judy have heard this before. I have a client whose daughter is on the autism spectrum, extremely high functioning autism, in the top 10% of her graduating class in high school. And because her part of the spectrum really just means that she likes math and programming, and she just doesn't really like people. And so that's great. She studies all the time. She doesn't go to parties, and she's basically going to get a full ride scholarship to any university she applies to. And she started up 2 businesses for girls in STEM. Like, I was like, she might be the next Mark Zuckerberg for all we know. And part of the goal of special needs trust is the whole, you know, maintaining public benefits aspect of it. But it's one of those things, like, for her, I don't think she will need public benefits. I really think that she's going to be incredibly successful in her life. But, you know, we still set up special needs trust for her, just so that the parents could have an insurance policy. So she will be able to maintain public benefits in the event that she actually needs them. And there's actually a whole area of benefits planning people who actually say that perhaps all of us need first party and third party special needs trust, so that we can put our income into the first party special needs trust. And then later on down the line, should we ever need to qualify for Medicaid, then we could still qualify for public benefits, but still have the bulk of our estates in our first party special needs trust. And so this is going to get on a long rabbit trail, but ultimately, what I do tell my clients is that you are never one and done, unfortunately. And that's one of the reasons why I'm glad that Mei Ling is trying to update her estate plan, because your situation changes, your family situation changes. The plan you have with a 4-year-old and a 6-year-old, I actually have a 4-year-old myself. The plan you have with a 4-year-old and a 6-year-old is not the plan you have with a 14-year-old and a 16-year-old, and that's not the plan that you have with a 36-year-old and a 34-year-old, and on and on. Because, as you know, obviously, as your children get older and their needs change, your estate planning, the way you structure things change. You may decide that, you know, your children should get their money outright. You may decide that, you know what, the daughter on the spectrum is actually the more responsible one, and the neurotypical one, well, she ended up being the screw up. And you just kind of don't know until you know what kind of children what kind of adults your children are going to be. And I say this with all the love in my heart, because I always tell my clients that I was the kid who, if you gave me $100,000 when I was 18 years old, I would spend it immediately on purses and shoes, and I would be homeless in a cardboard box, living with all the things that I bought. And I'm the living case of why you should probably not leave all your money outright to your 18-year-old, which is why we have minor contingent trust. So that was a really long way of saying the only way I could really advise you is to look at what you're trying to do and figure out what your estate plan is going to be. And to actually, you know, another thing that came out in other presentations that I think is worth reiterating here is for parents to put your posse of professionals together, and to have, for estate planning, you know, your accountant, your financial planner, and your attorney, we all do different things, but all the things that we do are really important and are related. Just like how I'm sure you have your team of doctors and therapists and care managers in schools and teachers and everybody else coming together and working together. And so making sure that everybody is on the same page of what your financial goals are helps, so that I understand what they think you need, and then I can figure out the best legal structure to create it.
Okay, thank you so much. That makes sense.
There was another question in the chat. What is the difference between guardianship of item versus estate guardian? Not very sure of the spelling.
Okay. I think what they meant to say was guardian of person versus guardian of the estate. And the guardian of the person is kind of what it sounds like. The person who decides where the ward lives, what medical treatment the ward should get, and you know, basically the everyday caretaking of the actual person, the body of the guardian, but also the, you know, educational opportunities and enrichment activities, whether or not they should be doing that. The guardian of the estate is essentially the business manager. Where does the money go? And that's why I say that they're not necessarily the same person, because, you know, I joke and I say that, well, I ended up being a lawyer, so I'm more responsible now, even though I was not very responsible when I'm younger. And my sister's a doctor, and so she's actually my mother's guardianship election for the guardian of the person, and I'm the person that's her guardian of the estate, because I basically can handle the money, everyday aspects of one, you know, trying to manage the business aspects, whereas my sister would definitely be the best person to handle the physical, medical aspects of living. And as I said in my presentation, the guardian, you don't necessarily have to have a guardian of the estate, especially if you are the guardian to a disabled adult who never really worked in life and probably won't inherit anything significant. And so for a lot of my clients, all we do is appoint the guardian of the person, like the parent as a guardian of the person, and appoint a representative payee for their Social Security account. And so the guardian, there is no estate if there's just a Social Security account and a representative payee. Oh, okay, so I saw the question. Do we need to get two different guardianships? The same person can't do that. No, you don't have to get two separate guardians. The same person can be both, but they are two different things. So it would just be done a little bit, it could be all done at the same time with the same person, but they are two different jobs that the court wants you to think about, because the court understands that the person handling the money is not necessarily the person you want handling all the medical and the emotional growth stuff. So, but it can all be done by the same person at the same time in the same order, but it doesn't necessarily have to be the same person. Happy to answer the question.
Couldn't unmute myself. For those of you who need to log off, I did put the survey link in the chat box. And I also am sharing, there's 2 amazing conferences coming up free for family members and for people with disabilities. One is from Family to Family Network, and it's called Creating a Meaningful Life. So Jennifer so eloquently shared with us the legal aspects of when your loved one is older. What this conference discusses is isolation, loneliness, customized employment, accessing services, the importance of belonging. So sort of those social and emotional challenges that we have with our loved one. And then we are also having through Lend, the program that Hazel is a part of, we are having a fabulous, fabulous conference, and I'm going to share the brochure for that as well. Really amazing, unconscious bias and cultural blindness in disability services. Because sadly, it is not surprising, but people with disabilities are often marginalized and not getting the services they need. Persons that are not American are being marginalized and not getting the services they need. So this conference will address those issues, discuss them, and bring them out in the open. We have national speakers for both conferences, and again, they are free for family members and self-advocates. If you're on this call and you would like continuing education credits, they have those as well. Hazel?
Yeah. Are there any more questions? Just checking. No? Okay.
Going once, going
Yeah,
twice?
thank you. Well, if anything, Jennifer, thank you for sharing this lovely talk with us. I believe she shared her contact details at the last slide. If you want to type your email in the chat as well, if anyone wants to reach out to her, feel free to. Let me just go ahead and type that in case.
And please, please fill out the survey.
Yes, and we will appreciate if you fill out the survey. If not, feel free to contact Jennifer with more information if you need. And I'm sure she'll be more than happy to respond to you. But in the meantime, thank you everyone for joining us today. Fill out the survey if you can.
Hazel, you mentioned before that you provide the Chinese translation.
Yes, yes.
I'm late today, so I didn't hear them clear. Will you provide the
Yes.
Chinese?
Yes. Yeah,
Okay,
so our translation, our summary notes, it comes out as a summary. So it's like, instead of like a audio translation, it's just like a PDF Word document kind of thing. And it takes about 3 to 4 weeks because we need to summarize the talk, and then we have our translators working on it, and it comes out in Chinese. So yeah,
we
just
will
look
send
out
that
for
to you, Mei Ling.
Yes.
Okay, thank you very much.
Do be patient with us, but yeah, it's coming. Thank you. Yeah,
Thank
and
you
if
very
anything,
much.
just feel free to reach out to us, and we'll be sending the slides as well with the summary notes later on. So thank you, everybody, and have a good rest of your Saturday.
Thank you, everybody. I had a great time. Great questions.
Thank you. Jennifer and Hazel, if you could stay on for 1 minute.
Do you want to stop the?
Thank you. You always are so good about telling me.